So it's my great honor and pleasure to share today my opinion on the current scope of protection by the Czech Republic of investments after the BITs in force, and also the outlook on the future. Let me make a brief introduction. In the early 60s, developed countries embarked upon a process of gradual investment liberalization. By the end of the 70s, it was the recovery from the oil shock. 80s, the national and international policy on foreign direct investment tended to establish international rules on the subject. 90s, most effective ways of attracting foreign direct investment and gaining benefits from it was focusing on. And then, after the world of the former socialist country began to change, in the end of 80s, the Czech Republic opened the borders. The international legal frameworks for foreign direct investment consist of many kinds of national and international rules and principles. The structure depends on the interchange and mutual effect of customary international law and national laws, while the substance relies on a multitude of international investment agreements and other legal instruments, specifically on bilateral investment treaties. The term international investment agreement is broader than bilateral investment treaty, although more than 98% of known international investment are bilateral investment treaties. Thus, the modern international economic investment law is largely based on international agreements at the first range of the BITs. The power of the state to admit or exclude aliens, physical persons or companies from its territory, to regulate the operation of all economic players, and to take the property of aliens in pursuit of public purposes is based on international law. On the one hand, the principle of territorial sovereignty establishes that states exercise their exclusive jurisdiction over persons and property in its territory. On the other hand, the principle of nationality recognizes that each state has an interest in the proper treatment of its nationals and their property abroad, i.e. by and within other states, and may invoke the rules concerning the responsibility of states for injuries to aliens and their property in violation of international law through the exercise of diplomatic protection of BITs. BITs are a principal element of the current framework for the protection and stimulation of foreign direct investment in the host country. A reason for the conclusion of BITs by the Czech Republic should have been apparently the stimulation of new investment flows, assuming that foreign direct investment could contribute to economic development. However, it remains questionable, as my co-speaker said, whether BITs play a major role in stimulating those desired flows. As was said, the World Bank's report 2003 said that BITs do not seem to have increased flows on investment to the countries. Based on the 2002 study on 20 years of data, which indicates that countries that had concluded a BIT were no more likely to receive foreign investment than were countries without such a pact. All BITs include, of course, provisions concerning fair and equitable treatment, full protection and security, national treatment, protections against expropriation and nationalization, and recourse to dispute settlement. What is the level of protection by the Czech Republic by taking stock of the most frequent treaties in the arbitration, specifically those concluded between the Czech Republic and Belgium, Luxembourg, Canada, Croatia, Germany, Israel and the Netherlands, United Kingdom and United States, and with Austria, China, France, Korea and Switzerland as possible examples on the other. Dealing with the purpose and object of BIT, the conclusion might be that the premises of the Czech Republic BITs are drafted in terms for enhancing economic cooperation and the creation of a favorable investment climate and stimulation for business initiative. There are many variants of such language that it is hard to generalize regarding its actual role and importance. The narrow preambles language might have an important impact upon interpretation of the treaty provisions and the treaty's application in the context of disputes between foreign investors and host states. The balanced preambles might help to ensure that tribunals do not view it as legitimate to resolve uncertainties in treaty interpretation as to favor investor interests. The subject matter provisions scope of any BIT is determined by the definition of two terms, investment and investor. It was said that national is any natural person, although the permanently residing in a contracting party under the Czech-Canada BITs is also the case. Company must be legally constituted in accordance with the laws and regulations of a party. The definition of companies relies merely on the criteria of incorporation, not on seat and control. Although this does not appear to be the legal rule, some recent BITs may also continue to offer two definitions, one relating to one party and the other relating to the other party, in particular the Czech-UK BIT Article 1C. The Czech BITs usually define investment in a broad and comprehensive manner, seeking to promote foreign direct investment by safeguarding the investors' interests. It was criticized by my co-speaker, but it is in the future to perhaps renegotiate the BITs that exist now. If alleged investment cannot be shown to be in the territory, of course, then the protection are not given. The most common standards of treatment in BITs in use are most favored nation clause standard and the standard of fair and equitable treatment. The two are known as relative or contingent standards because they do not define expressly the contents of the treatment they accord, but establish it by reference to an existing legal regime, that of other aliens in the one case and that of host state nationals in the other. The legal regime to which reference is made changes over time, and the changes apply to the foreign beneficiaries of MFN or national treatment as well. Every BIT of the host state, meant the Czech Republic, contains a MFN clause. Most favored nation clause is a standard of treatment, not a customary rule of international law, and thus an MFN obligation exists only when a treaty clause creates this. In the absence of the treaty obligations, nations retain the possibility to discriminate between foreign nations in their economic affairs. The beneficiary state and or the investor may direct claim MFN treatment only for the category of person or things that receives or is entitled to receive certain treatment or certain favor under the right of the third state, and they have to be in the same relationship. At the heart of the measures that foreign investors are not discriminated in relation to domestic counterparts lie issues related to the principle of national treatment. The national treatment is qualified as absolute or not contingent because it is supposed itself to establish, through its formulation, its unchanging content. National treatment may be interpreted as formal equity of treatment between foreign and domestic investors. The national standard is given in the BITs with France, Germany, Israel, Korea, Switzerland, the UK and the USA, and the national standard is not granted to Austria, Belgium, Luxembourg, Canada, and Netherlands. The BIT might contain specific restrictions and exceptions of the MFN as well of the NT standard, which exclude certain areas from its application. Such areas include inter alia regional economic integration, matters of taxation, government procurement, and country exceptions. The state parties excluded in Annex in 1991 Czech USA BIT for the Czech investors existing and of future measures in designated sectors from the reach of the national treaty obligation. It is here given ownership of real property, mining on the public domain, maritime services, and primary dealership in U.S. government securities as an example. The principal measures against which investors seek protection are expropriations, nationalizations, and other major cases of deprivation of property and infringement of property rights of investors. In the international law of state responsibility for injuries to aliens, a sharp distinction was made between measures affecting the property of aliens and those dealing with their rights from contracts with the state. The BITs met the requirements established in recent international law. The measures have to be taken in the public interest. They should not be discriminatory, and they should be accompanied by full compensation. They allow that appropriate compensation should normally be paid, stipulating that any conditions or prerequisites for property takings with a country's territory are to be determined by the host state and are subject to the review by the judicial or other or independent authority of the party. It is the case of Austria, Canada, Germany, Israel, Korea, UK, USA, BITs, and the international arbitration is previewed in the BITs with Belgium, Luxembourg, France, Netherlands, and Switzerland. These provisions, however, assure investors not to indemnification in all cases, but only of non-discrimination in the award of compensation. A major category of investment protection provisions in the recent BITs consists of measures that seek to address concerns that are specific to foreign investors because their investment crosses national borders, their base of operation and profit centers are in another country, their managerial personnel is often foreign, etc. The main such provisions are those concerning the transfer of funds by the investor outside the host country and the possibility of employing foreign managerial or specialized personnel without restrictions. These matters fall within the broad area of the regulations of movement of capital and payments. So we are now coming to the settlement of disputes. Investor-to-state disputes are normally subject to the jurisdiction of the host state's courts. The international investment agreements contain also provisions on dispute settlement. This is the case of, for example, this is the case for Energy Charter Treaty, which covers the possibility of investor-state arbitration. BITs address the issue by stipulating the settlement of dispute towards facilitating the execution of eventual arbitral awards. This is the task of the 1958 New York Convention on the recognition and enforcement of foreign arbitral awards, which has performed with considerable success. The arbitration clauses under recent BITs give the investor the possibility to submit an investment dispute to ICSID, ICC, SCC, or ad hoc. And as reported by UNCTAD on the last development in investor-state dispute settlement, of the total 357 known disputes, 225 were filed with the International Center for Settlement Investment Disputes, or under the ICSID additional facility, 91 under the United Nations Commission on International Trade Law, Ancestral Rules, 1976, revised in 2010, 19 with Arbitration Institute of Stockholm Chamber of Commerce, 8 were administered by Permanent Court of Arbitration. 4 are ad hoc case, 5 ICC, and as the figure shows, 1 at Cairo and 4 cases are known. As you know, the Czech Republic was involved in many disputes. There is a list: European Media Ventures, Franche, Prenreka, Binder. So it was under Belgium, Luxembourg, BITs, Canada, Croatia, Binder, Germany. Then Georg Nepolsky, Germany, Phoenix Section, Israel, CME, Eastern Sugar, Investma, Saluka, Nagel, and Lauder. Termination of BITs. In accordance with Article 24 of the 96 Vienna Convention on the Law on Treaties, a treaty enters into force in such manner and upon such date as it may provide or as the negotiating states may agree. Article 54 says that the termination of a treaty or the withdrawal of a party may take place, A, in conformity with the provisions, or at any time by consent of the state parties. The Czech Republic concluded all 80 recent BITs after 1990. On the other hand, the Czech Republic has terminated investment protection with other European Union member states by consent of the parties in such a way that the agreements appear to no longer provide residual protection to existing investments. The Czech Republic has used the two-step method to terminate BITs with Denmark, Slovenia, Malta, Estonia, Ireland, and Italy. The two-step process appears to ensure that treaty protections from existing investments do not live on for a further time period. The report of the United Nations Conference on Trade and Development cautions that the termination of a BIT is of little immediate significance since the state continues to be bound by it for the period of the survival clause. However, this opinion seems to presume a unilateral termination by one party, and does not devote attention to the possibility that states might elect to terminate a treaty by mutual agreement. The mutual agreement seems to revoke any residual protections which purport to offer residual legal protection to investments that were made prior to termination, i.e. ensuring longer-term legal protection even after termination of a treaty. BIT with Slovakia was terminated in 2004, and BIT with Ireland is terminated, is being ratified. Then outlook on the future. In considering current trends concerning the BITs, it is important to pay particular attention to their impact on development. The objective of the developing countries might seek foreign direct investment in order to promote their economic development. The question arises, therefore, as to whether and how far the Czech Republic as a host state participating in BITs can maintain a certain policy space to promote their development by influences through direct or indirect measures, the amount and kinds of foreign direct investment that they receive and the conduct of the foreign firm involved. The actual situation in international law and policy with respect to investment lacks coherence and clarity, and the exact relationship among legal actions and measures at the various levels is unclear, since many developments in question are relatively recent and little actual practice, and even less case law, judicial or arbitral, has had the chance to crystallize. A dichotomy in investment policy trends is emerging. It is characterized by simultaneous moves to further investment liberalization and promotion on the one hand, and to increase investment regulation in pursuit of public policy objectives on the other. While foreign direct investment should achieve growth of the economy in the Czech Republic, the BITs remain to have the potential to reduce the overall decline in cross-border direct investment flows. They must remain effective in operation provisions on investment promotion and continuation of international cooperation. The international investment agreements universe is expanding rapidly with over 5,900 treaties at present, on average 4 treaties signed per week in 2009. This system is rapidly evolving as well, with countries actively reviewing and updating the international investment agreements regimes as proposed and suggested by my co-speakers. And in my opinion, it is the way to go. So let me make a conclusion that the BITs as a form of international investment agreements in order to promote effectively direct investment are needed today more than ever. I would like to make a closing remark saying the protection of foreign investment in the Czech Republic is on a very high standard, international standard. However, the protection of the investment from abroad is quite close connected with the responsibility of the host state based on the acts of its state's organs, which are attributable to the state according to Article 2 of the draft article on responsibility of states for International Wrongful Act. If the host state would not act against international law, it does not act wrongfully, the BIT might protect the investment on the highest level. Nevertheless, the investor would not have any reason to sue the host state with any success, even if they entered into an investment dispute. Stephen Enway addressed the contribution of money, duration, element of risk, good faith, and contribution to the whole state development, which are the prerequisites to have the protection given by BIT in sense of salinity test. Perhaps we, as the Czech Republic, have to think to renegotiate this issue of contribution, but in my opinion, it is a topic of the next conference. Thank you very much for your attention.